Court proves massive bank fraud, 370 monitors penalty that could end Trump's business. This is breaking, and it is significant. A New York court has formally ruled that Donald Trump and the Trump Organization committed massive financial fraud, not as a political allegation, not as media speculation, but as a legal fact established by documentary evidence. We are not talking about opinions. We are not talking about partisan debate. We are talking about signed financial statements, bank records, internal emails, and a summary judgment that removes any remaining doubt about whether fraud occurred. The potential consequences are staggering, up to $370 million or more in penalties, long-term business restrictions, and a ruling that could fundamentally dismantle a real estate empire built over decades. Tonight, we are going to break down exactly what the court proved, how the fraud worked, and why this ruling changes everything going forward. One of the most misunderstood phrases in the headlines right now is this: the court proved fraud. Let's slow this down. In this case, the judge issued what's called a summary judgment. That means the court reviewed the evidence and concluded that no trial was necessary to determine whether fraud occurred, because the documents themselves were overwhelming. In plain English, the judge looked at the numbers and said, "There is no reasonable dispute here." This matters because summary judgment is rare, especially in cases involving complex financial structures and powerful defendants. The court found that the Trump Organization repeatedly inflated asset values, misrepresented property characteristics, and used those inflated numbers to obtain financial benefits from banks. And critically, the court rejected the idea that these were innocent mistakes. The ruling states that the discrepancies were so extreme, so consistent, and so one-sided that they cannot be explained away as accounting errors. This is not about one wrong number. This is about a pattern. Every major fraud case has a single document that anchors everything. Here, that document is the statement of financial condition. This is not marketing material. This is not a press release. This is a formal financial statement signed and submitted to banks representing the defendant's net worth. By signing it, you are legally certifying that the information is accurate to the best of your knowledge. The court focused heavily on this document because it was used over and over again to secure loans, negotiate interest rates, and obtain favorable financial terms. And this is where the case collapses for the defense. Let's start with the most striking example: Trump's personal apartment in Trump Tower. For years, financial statements claimed this apartment was approximately 30,000 square feet and valued it at over $300 million. But here's the problem: the apartment is not 30,000 square feet. According to architectural records, floor plans, and testimony, it is approximately 10,996 square feet. That is not a rounding error. That is nearly 3 times larger than reality. Why does this matter? Because square footage directly drives valuation. By tripling the size on paper, the asset value skyrocketed, creating hundreds of millions of dollars in paper wealth that did not exist in reality. That artificial wealth was then used to justify better loan terms. This is math, not hype. You may have heard this argument: the banks were happy, they got paid, so where's the crime? The court rejected this completely. Under New York law, fraud does not require a complaining victim. Internal bank documents showed that lenders relied directly on the stated net worth figures when approving loans and setting interest rates. Risk officers cited Trump's purported net worth as a key factor in approving favorable terms. The pattern doesn't stop with the apartment. Take 40 Wall Street. Bank appraisals valued the building at approximately $200 million, but on Trump's financial statements, it appeared at over $500 million. Testimony revealed that this relied on manipulated capitalization rates, a technical but critical lever in real estate valuation. By adjusting the rate unrealistically, an average building can be portrayed as a premium asset. The court noted that these assumptions were unsupported by market reality and consistently skewed upward. Another key asset, Seven Springs Estate, shows the contradictory approach even more clearly. For tax purposes, the property was described as restricted land, lowering its taxable value. But for loan purposes, it was presented as a high-value development opportunity worth hundreds of millions. The court made it clear you cannot tell one government one thing to reduce taxes and tell banks the opposite to increase borrowing power. That is misrepresentation. The judge's language in the ruling was unusually direct. The numbers were not merely optimistic, they were false. The size discrepancies, valuation gaps, and inconsistent representations across agencies showed intent, not negligence. Importantly, the court rejected the defense that Trump relied entirely on accountants. Testimony showed that financial statements were reviewed, questioned, and sometimes sent back for revisions when totals were deemed too low. This places responsibility at the top. As of now, fraud has been legally established. The remaining question is penalty. The Attorney General is seeking disgorgement of ill-gotten gains, civil penalties potentially exceeding $370 million long-term or permanent restrictions on business operations in New York. The court has appointed an independent monitor, a retired federal judge, to oversee financial activity inside the company. That level of oversight is rare and signals a lack of trust in internal controls. Even before final penalties, lenders, insurers, and partners are recalculating risk. Banks react to findings. That means tighter lending terms, higher interest rates, or outright refusals to refinance existing debt. For a real estate business, access to credit is oxygen. Restrict it, and everything slows. The political implications are unavoidable. Supporters may dismiss this as politically motivated. Critics point to documents and say the math speaks for itself. The court's approach matters. This was undisputed evidence judged by a neutral arbiter, not a jury swayed by rhetoric. That gives the ruling durability. Looking forward, analysts see three paths: a negotiated settlement involving massive payments and restrictions, a court-ordered restructuring or partial liquidation, a prolonged appeal process that freezes expansion and financing. None resemble business as usual. This case sends a broader message. Financial statements are not storytelling tools. They are legal instruments. Inflate them, and consequences can dismantle an entire organization, no matter how powerful the name at the top. Democracies do not erode overnight. They weaken when rules appear optional for the powerful. This ruling reinforces that trust and accountability still matter, even at the highest levels. The final penalties are pending. Appeals will happen. Delays are likely. But the trajectory is clear. This business empire was not challenged by politics. It was challenged by arithmetic, documentation, and law. And that changes everything.